You're watching Capitol View, Sunday morning talk focused on the political scene in Arkansas.
Welcome back to the program. Joining me now, John DiPippa, Dean Emeritus of the Bowen School of Law. Thank you so much for being here.
You're welcome.
We got a lot to break down, so I added a little extra time for us here.
Okay, great.
Let's begin with this latest case in the U.S. Supreme Court's docket dealing with, it actually was dealing with nationwide injunctions, but it was a lawsuit centered around this birthright citizenship. So I kind of want to do this in a very piecemeal fashion so that we don't get too far ahead of ourselves. Let's talk about what they did in terms of precedent setting on nationwide injunctions. And I don't know the history of when one federal court could make a nationwide injunction. It hadn't gone on forever. It's been somewhat recent in terms of history.
So let's sort of break that down in a little bit broader perspective, okay? Federal courts have what's called powers of equity, which means that they can fashion remedies that are flexible, that give relief to the parties. So federal courts have always had the power to issue injunctions. However, only since 1976 have the courts had the right procedural tools to issue these injunctions from one district court that would be nationwide and prevent the executive from enforcing policies. So they're relatively recent, but the power to issue them has always been there. They just didn't have the right sort of format. Now, what's happened though is that equity always had things like them. They were called the bills of peace, where if there are a bunch of people who had the same problem, an equity court, even in England, could say, hey, you know, I'm going to issue one order and it's going to take care of all these cases. So they've been around, but not in this exact form. They've been around for a long time. What the Supreme Court said, however, is that they weren't sufficiently like the nationwide injunctions in 1789 when the Congress passed the act that gave the courts this power. So because they weren't close enough to what we're doing today, court said district courts don't have that power.
All right, that's got big ramifications because, like you said, we've been probably watching this for 48, 49 years now in our nation's history where, and actually sometimes we get conflicting injunctions. You know, one court says ban on it and another court does not put a ban on it, and that leads to all kinds of ramifications there. How do you see this playing out now? How does someone who wants to get a nationwide injunction on something, what's their MO? What's their protocol?
So the protocol, according to the Supreme Court majority, is to file a class action. And there are a couple different kinds of class actions, but these class actions would be called B2 class actions.
B2?
B2.
Okay.
Rule 23, B2.
Okay.
And the reason is they're different from like the class actions where you get notice that say, you know, the telephone company charged you too much, and then you have to give notice to everybody in the country like you. These class actions are designed for, say, common civil rights violations. I filed a couple of those when I was in practice. Now, they're not difficult to do, but they're cumbersome because you have to find and define the number of people who are in your class. You've got to decide how many people they are. You have to show that their claims are like everybody else's claim. You have to show that they have common law and fact issues. And then you have to show that there's no other way to do this except to join them in a class action. So there's like several steps before you even get to the issue, which is, can you stop the executive from doing these things?
Yeah. Okay.
Now, there have already been class actions filed after this case.
Okay. So let's just take this birthright citizenship case as an example, and maybe you could contrast this with a hypothetical Second Amendment case that could come someday that I guess you've got different people on different political persuasions that would say, I'd be for this or against this. So kind of walk me through how you think this birthright citizenship potential, these legal cases may combine or form some sort of national, some sort of national filing here.
Well, you know, in a word, the technical word is it's a mess. Because what this means is you'll have different lawsuits in different parts of the country, and they may come up with different rulings. So, for example, even after the birthright case last week, the rule is in place, the injunction's in place for the 22 states who filed them and the named plaintiffs. So some people in the country are now protected by this law, by this injunction, but other people are not. So you have the prospect of two different situations. One where an unconstitutional law is being enjoined, and another where an unconstitutional law is actually taking effect. So think about, say, California decides to ban weapons, all weapons, right? Well, you couldn't get a nationwide injunction to stop them from doing that. Now, you can get it within California, okay?
Could you get it within the state of California? Would you get it within the jurisdiction of that federal court?
Probably within, within the jurisdiction of that district court.
Yeah.
So now you have a patchwork within California of district courts. But nationwide injunctions really don't make sense for state laws. They make more sense for federal laws because federal laws apply across the whole nation. So it's more apt to think about a future, say, Democratic president who passes or gets into effect some rule that limits weapons. That's where the nationwide injunction would have the same sort of patchwork mess we have now. And so nationwide you ban weapons, some jurisdictions enjoin that, some jurisdictions allow it to go into effect.
So I would think that for the legal field, this becomes much more confusing and much more difficult to figure it out, or does it create more opportunity and more creativity for the legal profession? What's your take on how you think people will adapt to this?
Well, I think people will adapt in the sense that they'll start filing class actions. But the problem with that is that there are rules about when you can file them and a whole bunch of other things. And so the adaptation has to come with being willing to spend more money, because it takes more to do them, and to wait longer for a final resolution. Because now we're not talking about, say, something in the weeks, we're talking about something in the months. And it's also important to remember that these were temporary injunctions. All they said to the government was, we're just going to freeze the status quo. Right? Just don't go forward until we figure out what the outcome of these cases is going to be.
Yeah.
So they weren't really even preventing the eventual policy. They just said, look, let's not mess with the status quo until we resolve these cases.
And that status quo and those cases had to go up through the different district courts, appellate courts,
That's
and
right.
then ultimately the Supreme Court. So where are we? Let's take this birthright citizenship 14th Amendment case, for example. Where are we with that now that the Supreme Court has made this ruling about injunctions? How does it progress?
Now, the court has sent those cases back to the original courts. And as I said, there's a preliminary injunction that prevents the order from going into effect for the named parties. But the other thing the court said was some of the plaintiffs in these cases were the states. States were saying, look, this birthright citizenship order is going to harm us in a number of ways. And the court said, we're not sure. We need more facts. So they sent it back to the district courts to decide if the states could also get an injunction that would prevent the order from going into effect within those 22 states that joined it. So right now, the order is sort of being argued in the district courts about, okay, how broad can we make this? Who are we going to enjoin? Which states? Which parties? How do we craft it so that it's not a nationwide injunction, but it still applies to the states? And what the states have said was, look, we can't just draw a line at our boundaries. People move across boundaries. So if our problem is with our residents and somebody from another state comes in, well, they're our resident now, and we don't know when they're coming, and we don't have, checks on them. So we need something like a nationwide injunction that says anybody who comes into our state is protected.
Is there still a path for nationwide injunctions to occur?
Only in a very narrow slice, and that's what I was saying about the states. The states are arguing that, look, we don't exist in a vacuum. We exist among states where people are free to move. We need something like a nationwide injunction. But that's exceptionally narrow. Otherwise, you couldn't even call them nationwide injunctions. You have to call them injunctions limited to the relief the parties need. the parties here being states.
All right, we got about a minute and a half left, and I'm going to push you a little beyond your normal boundaries of just giving unbiased opinion here. When you look at this birthright citizenship lawsuit, to me it's pretty clear if you're born here, you're here. I mean, what's to dispute on this? What's the legal argument for saying it doesn't apply?
There aren't any, to be perfectly honest, and it goes against the text of the Constitution and the prior history in the Supreme Court and the way we've handled things. The technical argument is that people who aren't citizens aren't subject to our jurisdiction, and that's in the language. The problem is, every court who has heard this case, and there are 3 so far in the lower courts, have said it's patently unconstitutional. And the game that the Trump administration played was they didn't challenge that. They said, oh, you just can't give us a nationwide order.
Right.
And so the game was, we're going to get to enforce this on people who don't have the ability or the wherewithal or the time to file an individual action.
Yeah, interesting stuff there. All right, he's John DiPippa. He is the Dean Emeritus of the UALR Bowen School of Law. Always great to get your take on everything. So stay cool this summer on all your bike riding around here. So you're looking good and fit. I'm proud for you to be in there. Thanks for being with us.
You're welcome.